The subcommittee will come to order, and welcome. I want to thank all of you, especially all the left behind parents I see in the audience, for joining us this afternoon to discuss what the U.S. Department of State's second annual report under the Sean and David Goldman International Child Abduction Prevention and Return Act tells us about the department's implementation of the Goldman Act thus far. It is worth noting that the numbers of new abductions from the United States in 2015 remain below the pre-Goldman Act mark, probably due to increased abduction prevention. So I want to commend the department for a myriad of efforts it has undertaken on the prevention side. According to the report, 600 more children were abducted to other countries last year, quickly replacing the 229 children abducted in various years, not just last year, but obviously previous years as well, who were returned. Overall, approximately 1,000 children remain in a foreign country, separated from their American parent. As many of you have experienced, international parental child abduction rips children from their homes and whisks them away to a foreign land, alienating them from the love and care of the parent and family left behind. Child abduction is child abuse and continues to plague families across the United States and across the world. For decades, the State Department has used quiet diplomacy to attempt to bring these children home. In a hearing I held on this issue back in 2009, then Assistant Secretary of State Bernie Aronson called quiet diplomacy a sophisticated form of begging. Thousands of American families suffer unspeakable agony from years of unresolved abductions, confirm that quiet diplomacy is inadequate. Of course, conversations and contact are important, but it needs to be backed up with concrete actions as well. In 2014, Congress unanimously passed the Goldman Act to give teeth to requests for return as well as for access. The actions against non-cooperating governments required by the law escalate in severity and range from official protest through diplomatic channels to the suspension of development, security, or other foreign assistance, as yet consistently fails to comply with the Hague Convention. Devin Davenport, who has testified before this subcommittee, has won every one of his 24 appeals in Brazil's courts over the last 7 years, and yet he still cannot get his daughter, Nadia, home. If there ever was a textbook case for sanctions, Brazil is it. They have met the legal threshold 10 times over. The report lists Japan as a, quote, country that has failed to comply with one or more of its Hague Convention obligations, specifically in the area of enforcement of return orders. Multiple parents have won Pyrrhic victories in court, only to discover Japan has what the report calls systemic flaws with enforcement. What remains inexplicable is why Japan was kept off the list of non-compliant countries for a second year, thus shielded from the imposition of sanctions prescribed by the Goldman Act, even though the department condemns them for systemic flaws in their ability to enforce court orders. Failure to enforce return orders is a sufficient trigger for landing on the non-compliant list. And I say that again, the plain meaning and text of the Goldman Act, that is enough to trigger being listed as non-compliant. One parent had to go outside of the convention framework to achieve enforcement in an extraordinary case resolved after the reporting period. The report should also have counted against Japan the 40, count them 40, pre-convention abduction cases it mentions as still pending, most of them for more than 5 years. Countries should be listed as worst offenders if they have high numbers. However, reporting is just step one. Once these countries are properly classified, the Secretary of State then determines which of the aforementioned actions the United States will apply to the country in order to encourage the timely resolution of cases. Such actions should bring an end to the nightmare of the Elias family, whose children, Jade and Michael, who live in New Jersey, but they now have been abducted to Japan, have been missing in Japan for 8 years. The father has testified before our subcommittee twice in the past, an Iraqi war veteran, and it is heartbreaking, like it is for the other families that are here, to know that their children languish in a setting where parental alienation causes severe and significant deleterious effects to their mental health. And that has been well proven, and the longer the years, the worse it arguably becomes for those children. We have a panel of family members, left behind parents, who will be testifying after Ms. Christensen, but I would like to thank them for being here, and I'd like to now introduce Ms. Karen Moore, that have been pending for more than a year. And again, Japan, most of these are more than 5 years. Countries may also be listed if their law enforcement, judiciary, or central authority for abduction regularly fails in their duties under the Hague Convention or other controlling agreement, or if the country simply fails to work with the United States to resolve the cases. Accurate reporting, including inclusion of the worst offenders list, is critical to family court judges across the country and parents considering their child's travel to a foreign country where abduction or access problems are at risk. However, Christensen, who has served as